Only mode.
Good afternoon, and welcome to our presentation on the OSC Exempt Market Reform Initiative. My name is Denise Morris, and I'm a lawyer in the Compliance and Registrant Regulation Branch. And here with me today are my colleagues Gloria Sang from the Compliance and Registrant Regulation Branch and Melanie Sokolsky, Legal Counsel in our Corporate Finance Branch. It wouldn't be an OSC presentation without the usual disclaimer, so I would note that the contents of the presentation shouldn't be modified without the express written permission of the presenters. So let's get started. In terms of what we're going to talk about today, we'll talk a little bit about the background on the exempt market review, how we got to where we are today. We're going to talk about the new capital raising prospectus exemptions, the amendments that we made to the existing prospectus exemptions. Then we'll shift gears a little bit and talk about the reports of exempt distribution. And lastly, we'll talk about the compliance and oversight as we are introducing new prospectus exemptions into Ontario. In terms of the background, we're not going to spend too much time talking about it, but at least we wanted to give you a sense of how we got to where we are today. So the original scope of the review included the review of the minimum amount and accredited investor exemption. And as we were going through this review, one of the themes that emerged from the comment letters and through our consultation process was the desirability of providing greater access to the exempt market for both issuers and investors. Given the feedback, the OSC decided to expand the focus of our review to consider whether there was potential to foster greater access by startups and small and medium-sized enterprises, SMEs, to capital while still maintaining an appropriate level of investor protection. As a result, on March 20th, 2014, the OSC published for comment a proposal that included 4 new exemptions: the offering memorandum exemption, a crowdfunding regime which included a crowdfunding prospectus exemption and a registration framework for a funding portal, the existing security holder exemption, and a family, friends, and business associates exemption. In terms of the new capital raising prospectus exemptions, on October 29th of this year, we published amendments to National Instrument 45106 that introduces an offering memorandum prospectus exemption in Ontario and amends the existing offering memorandum exemption in certain other jurisdictions. Subject to ministerial approval, the offering memorandum exemption is effective on January 13, 2016 in Ontario. On November 5th of this year, we published Multilateral Instrument 45108 that introduces a crowdfunding prospectus exemption and a registration framework for funding portals in Ontario and certain other jurisdictions. Subject to ministerial approval, the crowdfunding regime will be effective on January 25th, 2016. Today we're also going to talk about an overview of some of the other recent developments, including the adoption of the existing security holder exemption in Ontario, which became effective on February 11th of this year, and the introduction of the family, friends, and business associate exemption in Ontario, which became effective on May 5th of this year. Lastly, we're going to talk about some of the amendments that were made to the existing prospectus exemptions, in particular the accredited investor exemption and the minimum amount investment prospectus exemption. These amendments became effective on May 5th of this year. Now I'm going to turn it over to Melanie to walk you through the offering memorandum exemption.
Thanks very much, Denise. So I will just start by reiterating, as Denise already mentioned, that the offering memorandum exemption is not currently available for use in the province of Ontario. However, it is available in all other Canadian jurisdictions and is set out in Section 2.9 of National Instrument 45106. Subject to ministerial approval, amendments that would introduce this exemption in Ontario will come into force on January 13th, 2016. Many of you are likely familiar with this exemption, which allows for the distribution of securities to non-sophisticated purchasers, so your average retail investor, without a prospectus, provided that another type of disclosure document, known as an offering memorandum, is provided instead. The form of offering memorandum is set out in National Instrument 45106, and the required disclosure is somewhat less than what is required in a prospectus. So there are 2 models of this exemption, which we refer to as the BC model and the Ontario model, And the difference between the two really has to do with who issuers can sell to in reliance on the exemption and how much those purchasers can invest. So in BC and several other jurisdictions, an issuer can use this exemption to sell any amount of securities to any type of purchaser. Soon to be in Ontario and several other jurisdictions, there are limits on the amount that certain investors can purchase under the exemption, which I will describe in more detail momentarily. So while we did want to mention that there are different approaches to the exemption across Canada, what we will really be focusing on here today is the Ontario model. So in terms of who can issue securities under the exemption, the offering memorandum exemption is available to both reporting and non-reporting issuers, but is not available to investment funds. However, there are no other restrictions on the type of issuer that can rely on this exemption. There are, however, restrictions on the type of securities that can be distributed under the exemption. Issuers cannot rely on this exemption to distribute specified derivatives or structured finance products, as we really think that those types of novel or complex products should be offered with the protections of a prospectus if they are being sold to retail investors. There are no limits on the amount of capital an issuer can raise under the exemption, nor on the length of time an offering can remain open. Registrants can sell securities of related issuers under this exemption. However, we have added new companion policy guidance indicating that where a registrant is providing suitability advice to a purchaser in respect of an offering by a related or a connected issuer, we expect the registrant to be aware of the conflicts that can arise in these circumstances and also to take appropriate steps to respond to those conflicts in order to ensure that the registrant is meeting its regulatory obligations. For instance, the guidance notes that registrants should be able to demonstrate that they are addressing the conflicts by avoiding or managing and disclosing them appropriately. The recent amendments do not introduce any new restrictions on advertising. However, any marketing materials used in connection with a distribution under the exemption must be incorporated by reference into the offering memorandum. This means that marketing materials would be subject to the same standard of liability as the offering memorandum itself in the event of a misrepresentation. We have also introduced new companion policy guidance around the use of marketing materials under the offering memorandum exemption and our expectations of issuers and registrants in this regard. At a high level, the guidance indicates that an issuer or a registrant that uses marketing materials under the exemption should review the materials to confirm that they are consistent with the offering document and that they are fair, balanced, and not misleading, and also to determine whether any claims set out in the materials adequately refer to supporting information. The new guidance also includes a discussion on marketing materials that are prepared by a third party and notes, among other things, that an issuer or a registrant should not rely on marketing materials prepared by a third party without actually independently reviewing those materials prior to use. In terms of who can invest under the exemption, the recent amendments have retained substantially the same definition of eligible investor that exists today in certain jurisdictions, which requires investors to meet certain income or asset thresholds. Specifically, in order to be an eligible investor, a purchaser must have, first, net assets, alone or with a spouse in the case of an individual, that exceed $400,000, or second, net income that exceeded $75,000 alone or $125,000 with a spouse in each of the 2 most recent calendar years, and also must have a reasonable expectation that this income threshold will be met in the current year. So while there are no actual restrictions on who can invest under the exemption, the concept of an eligible investor is really relevant for the purpose of determining how much an investor can purchase. As I noted a moment ago, we are introducing investment limits, which will apply to certain individual investors. We think that this is important. Introducing the offering memorandum exemption in Ontario will open up the exempt market to retail investors that may not have been able to purchase in this market previously, and we think that investment limits are an important investor protection measure for these potential purchasers. So we've adopted a tiered approach to investment limits that's based on investor status. Accredited investors and investors who qualify to purchase securities under the Family, Friends, and Business Associates exemption are not subject to any investment limits. Similarly, non-individual investors are not subject to any investment limits. Eligible investors will be able to invest up to $30,000 under the exemption in a 12-month period. However, this $30,000 limit may be exceeded by an individual eligible investor who receives advice from a portfolio manager, investment dealer, or exempt market dealer that exceeding the limit of $30,000 and the investment itself is suitable for the investor. So these investors may invest up to $100,000 under the exemption in a 12-month period. Non-eligible investors will be able to invest up to $10,000 in a 12-month period. So I just note that the investment limits apply over a 12-month period and not a calendar year. So what this means is that each time an investor wants to purchase securities under the offering memorandum exemption, it will be necessary to look back to all investments under this exemption in the 12 months preceding that particular investment. So the next slide provides an overview of some of the other key features of the exemption. As another investor protection measure, all investors must sign a risk acknowledgement form on current 45106 F4. So while this is a requirement today for all of the jurisdictions that have the offering memorandum exemption in place, what the amendments do is introduce two new schedules that must be completed by individual investors. So these schedules require investors to do two things. The first is to indicate how they qualify to invest, for instance, whether they are eligible or non-eligible investors, and second, to confirm that they are investing within any applicable investment limits. The schedules also require details to be provided with respect to any registrant that has provided advice to the investor. We have also introduced new companion policy guidance that indicates that notwithstanding the representations made by a purchaser in the schedules to the risk acknowledgement form, we do expect an issuer to be able to explain what steps were taken to verify the representations made by the purchaser. We also recognize that in many circumstances, a registrant may act as agent on behalf of an issuer for this process. So in this regard, we refer issuers and registrants to additional guidance in Section 1.9 of the Companion Policy to National Instrument 45106 regarding steps that can be taken to verify the representations of a purchaser. I won't get into a lot of the details around this right now because Denise will discuss it in greater detail in a few minutes. In terms of point of sale disclosure, investors must be provided with an offering memorandum in the prescribed form. No changes have been made to the form of offering memorandum that currently exists and that is in use across the rest of Canada. However, the amendments do introduce some requirements for non-reporting issuers to provide investors with some disclosure on an ongoing basis. For instance, non-reporting issuers will be required to provide audited annual financial statements and an annual notice describing how the issuer has used the money raised under the exemption. Also, in Ontario, New Brunswick, and Nova Scotia, non-reporting issuers will be required to provide investors with notice upon the occurrence of certain key events, including a discontinuation of the issuer's business, a change in the issuer's industry, and a change in control of the issuer. There are two other features of the exemption that I'd like to note briefly before we move on. The first is that investors have a 2 business day right of withdrawal with respect to securities purchased under the exemption, and the second is that securities distributed under the exemption are subject to resale restrictions under National Instrument 45102. I'll now turn it over to Gloria, who will discuss the recent crowdfunding amendments.
Thank you, Melanie. Good afternoon. I'm here to talk about the crowdfunding regime that was recently published in Ontario and in 4 other provinces. As mentioned by Denise, Multilateral Instrument 45108 crowdfunding was published in final form on November 5, 2015. Subject to ministerial approval, it will come into effect on January 25, 2016. MI 45108 establishes a crowdfunding regime that consists of a prospectus exemption and a registration framework for funding portals. I will first discuss the key elements on the use of the crowdfunding prospectus exemption and then the registration framework. Now, crowdfunding is intended to facilitate capital raising for Canadian startups and small and medium-sized companies. As a result, MI 45108 sets out certain restrictions on the use of the prospectus exemption. Specifically, in order to use the prospectus exemption, the issuer must be incorporated or organized in Canada, have its head office in Canada, and the majority of its directors must be resident in Canada. However, the issuer's principal operating subsidiary may be incorporated or organized in Canada or in the US. In addition, the exemption is available to both reporting and non-reporting issuers. It is not available to investment funds or blind pools. Issuers may only offer certain types of securities under the exemption. These types of securities include common shares, non-convertible preference shares, and simple debt securities. These types of securities are intended to be straightforward and easy for investors to understand. There's a cap on how much money an issuer may raise. An issuer group, that is, the issuer, its affiliates, and any other entity that is engaged in a common enterprise with the issuer or its affiliate, is limited to raising $1.5 million on a 12-month rolling period. A crowdfunding distribution can only remain open for up to 90 days. In addition, an issuer may only distribute securities through a single registered funding portal. As a result, the issuer may only advise potential investors that it proposes to offer securities under the crowdfunding prospectus exemption and direct investors to that funding portal. For example, a bakery doing a crowdfunding offering could post a notice on its store window, hand out leaflets, or send a tweet to let its customers and others know that it is offering securities under the exemption and on which portal more information about the offering may be found. All other advertising and solicitation by the issuer is prohibited. All offering materials of the issuer must also only be made available to investors through that single funding portal. Regarding the offering materials, the issuer must prepare and provide to potential investors an offering document that describes the issuer and its proposed business. The issuer may also make available to investors a term sheet, a video, or other materials that summarize the information in the offering document. The crowdfunding regime contains a number of specific measures to make investors aware of the risks associated with a crowdfunding investment and to limit their exposure. These include investment limits. For retail investors, the limits are $2,500 in a single investment and in Ontario an annual limit of $10,000 in a total during a calendar year. For accredited investors, the limits are $25,000 in a single investment, and in Ontario we have established annual limits of $50,000 in total during a calendar year. The other jurisdictions do not have annual limits. In addition, in Ontario, there are no investment limits for permitted clients. In the other jurisdictions, permitted clients have the same limits as accredited investors. We expect a funding portal to take reasonable steps to confirm that each purchaser understands and complies with the applicable investment limits. A funding portal should have appropriate policies and procedures in place to confirm and verify the purchaser's investor status, the applicable investment limits, and whether the purchaser is in compliance with the applicable investment limits. In Ontario, these procedures must include obtaining a completed Form 45108F3, confirmation of investment limits, from the purchaser prior to accepting any funds from the purchaser. If a purchaser specifies that is an accredited investor or a permitted client, the funding portal should obtain further information from the purchaser in order to determine whether the purchaser has the requisite income or assets to meet the terms of the accredited investor or permitted client definition. In addition to investment limits, the crowdfunding regime includes requirements to ensure investors are made aware of the risks of investing in a crowdfunding offering. First, when entering the funding portal's online platform, the funding portal must take reasonable steps to confirm that the person or company understands that a distribution posted on the funding portal's online platform has not been reviewed or approved in any way by a securities regulatory authority or regulator. the distribution is risky and may result in the loss of all or most of an investment, and that the person or company may receive limited ongoing information about an issuer or an investment made through the funding portal. This could be done, for example, through a pop-up window on the portal. Second, prior to entering into an agreement to purchase securities, investors must complete a risk acknowledgement form that draws their attention again to the key risks of a crowdfunding investment, including the risk of loss, lack of liquidity, and limited information they will receive. Last, investors also have the right to change their minds. They may withdraw their offer to purchase within 48 hours of entering into the agreement to purchase the securities and within 48 hours of any amendments to the offering document. MI 45-108 establishes limited ongoing disclosure requirements on non-reporting issuers using the crowdfunding prospectus exemption. These requirements are similar to those required under the OM exemption. They will be required to provide investors and file with securities regulatory authorities annual financial statements, along with disclosures on how they have used the monies raised. As no specific form has been prescribed, issuers should consider whether disclosure on use of proceeds contains sufficient detail for a security holder to understand how the proceeds have been used. For example, the disclosure could include a breakdown of the amount allocated to fees, salaries, assets purchases, and development expenses. In Ontario, New Brunswick, and Nova Scotia, non-reporting issuers are also required to provide to investors a notice of specified key events within 10 days of the event occurring. These events are a discontinuation of the issuer's business, a change in the issuer's industry, and a change in control of the issuer. Reporting issuers must continue to comply with their ongoing reporting requirements under securities law. As noted earlier, MI 45-108 prohibits advertising and solicitation by issuers and by funding portals. We note that a funding portal may only advertise that is in the business of distributing securities under the crowdfunding prospectus exemption. A funding portal may not advertise a particular issuer or distribution. We would also like to note that shares acquired under the crowdfunding prospectus exemption are subject to resale restrictions. These shares may only be resold under another prospectus exemption or if the issuer becomes a reporting issuer. Our last slide on MI 45-108 covers the registration framework over funding portals. A funding portal may be registered as a restricted dealer, an exempt market dealer, or an investment dealer. A funding portal that is registered as a restricted dealer cannot be registered in any other registration category. For example, a funding portal cannot be registered as both a restricted dealer and an exempt market dealer. In Ontario, a funding portal registered as a restricted dealer cannot be affiliated with another registered firm. A restricted dealer funding portal is intended to be a specialized type of restricted dealer that can only rely on the crowdfunding exemption to facilitate distributions of simple securities. A restricted dealer funding portal will not be permitted to provide recommendations or advice. That means a restricted dealer funding portal cannot tell a purchaser that the securities are a good investment, that the securities meet the purchaser's investment needs or objectives, or that the purchaser should buy the securities. Exempt market dealers and investment dealers are allowed to use the crowdfunding prospectus exemption, but those that are currently operating will need to file Form 33-109F5 change of registration information that describes the change in its business operations. Exempt market dealers and investment dealers relying on the exemption will be required to comply with all of their obligations as an exempt market dealer or as an investment dealer, in addition to the applicable requirements and restrictions set out in MI 45-108. We note that a funding portal will not be permitted to participate in a distribution if the issuer is a related issuer. Now, funding portals carry out a gatekeeper role. They will be responsible for conducting background checks of issuers and of issuers' directors, officers, and promoters. For example, the funding portal should check, at a minimum, the existence of the issuer and its business registration, the criminal records of the key principals of the issuer, securities and disciplinary enforcement history, bankruptcy records, and where available, court records of litigation. A funding portal will be responsible for reviewing the offering document and other permitted materials for incorrect, incomplete, or misleading disclosures. Where it has identified incorrect, incomplete, or misleading information, it must have the issuer correct, complete, or clarify the information prior to posting. For example, if the issuer's constating documents indicate that the common shares contain restrictions on voting or contains redemption rights that allow the issuer to redeem the shares in certain circumstances, and the offering document does not contain this disclosure, the funding portal must have the issuer correct the offering document. If the funding portal becomes aware that the offering document or other materials may contain a statement or information that is false, deceptive, misleading, or that might constitute a misrepresentation or untrue statement of material fact, it must remove the documents from the portal. A funding portal is to deny an issuer access to the online platform if the issuer or any of its directors, executive officers, or promoters has pled guilty to or has been found guilty of an offense related to fraud or securities violations. Funding portals are also required to deny an issuer access to the online platform if the funding portal makes a good faith determination that the business of the issuer may not be conducted with integrity. The issuer is not complying with one or more of its obligations under MI 45-108, or the crowdfunding offering document or materials contain a statement or information that constitutes a misrepresentation or an untrue statement of fact. My last point is on the reporting obligations of funding portals. During the distribution period, a funding portal is required to terminate a distribution and report to securities regulatory authorities where it appears that the business of the issuer is not being or may not be conducted with integrity. In addition, funding portals are to report twice a year to the securities regulatory authorities information about the distributions it has acted as intermediary. This reporting includes information on distributions that were completed, on distributions that did not close, on issuers denied access, and on issuers that were removed from the funding portal. Now I'll turn over the presentation to Denise, who will discuss the family, friends, and business associates exemption.
Thank you, Gloria. So moving on, we're on slide 20 for those of you who are just trying to make sure where we're at. So the family, friends, and business associates exemption, as we heard earlier, was introduced in Ontario on May the 5th of this year. And the first slide provides a table just highlighting some of the key features. So the exemption is available to reporting and non-reporting issuers. There is no restriction on the size or the number of the offerings that can be conducted in reliance on this exemption. In terms of the investor, the purchaser, there is a qualification requirement. They have to be certain family members or close personal friends or close business associates of the principals of the issuer. And the other aspect to note on this exemption is the introduction of the risk acknowledgement form. And finally, that the particular section where the exemption is outlined is in 2.5 of National Instrument 45-106. So up until this time, Ontario had a narrow form of this exemption, which was known as the founder, controlled person, and family exemption, while the rest of the CSA jurisdictions had the family, friends, and business associates exemption. So on May 5th, when Ontario introduced the family, friends, and business associates exemption, we also repealed the founder, controlled person, and family exemption. It's important to note that this new Ontario exemption is largely based on the form of the exemption that exists elsewhere across the country, so we are substantially harmonized on this exemption. And effectively, this exemption allows issuers to raise capital from investors who are principals of the business or within the personal networks of the principals of the business. And this exemption was really introduced because it's intended to enable early stage businesses to raise capital from their immediate network and family and friends. So we want to highlight some of the key features of this exemption. So first is the requirement of a risk acknowledgement form. I think what's important to note here is that both parties to the relationship, so both the purchaser and the director or executive officer at the issuer, must confirm the relationship and sign the risk acknowledgement form. We think that given this exemption can be used to distribute securities to retail and unsophisticated investors, A risk acknowledgement form can be a useful tool to draw investors' attention to the risks associated with the investment and prompt them to ask questions about it. We also introduced some companion policy guidance around the meaning of the terms close personal friend and close business associate, since these terms are somewhat vague and there's no bright line test for who qualifies under these categories. The guidance outlines some of the factors that we consider to be relevant to determine whether someone is a close personal friend or a close business associate. As well, the guidance outlines circumstances where we would not automatically consider such a relationship to exist. So in terms of the relevant factors, you should consider the length of time you have known the person, the nature of the relationship between the parties, which includes such things as the frequency of contact between them, and the level of trust or reliance. If it's a close business associate, then things to look for are the nature and number of business dealings between the parties, the length over the period of time those dealings took place, and when was the last business dealing that the parties had together. A couple of points to note. The relationship between the parties must be direct and not indirect. So for example, the exemption is not available for a close personal friend of a close business associate of the director of the issuer. It has to be a close personal friend or close business associate of the director of the issuer. And second of all, just because you're friends with someone on Facebook does not mean that you are a close personal friend. We also added guidance in Ontario that the use of registrants, finders, or advertisers, as well as the payment of commissions or fees to find purchasers, is inconsistent with this exemption. We do not think that an issuer's principal needs to advertise to find their family or friends. The final point that I will mention is that similar to the other prospectus exemptions we're discussing today, securities distributed under this exemption are subject to resale restrictions as set out in National Instrument 45-102. I'm now going to shift to talk about the amendments that were made to the accredited investor exemption. So the first slide, again, is a table that provides some high-level key features of the exemption. So again, this exemption is available to any type of issuer. So unlike some of the other exemptions we talked about today, this exemption can be used by investment funds. In terms of investor qualification, the purchaser must be an accredited investor, but any type of security can be offered, and it can be any seller. And in particular, the exemption is outlined in Section 2.3 of National Instrument 45-106. So before sort of getting into the accredited investor exemption, I just thought we'd talk a little bit about the fact that this is one of the most used capital raising exemptions based on the information that we've gathered through our reports. In particular, it accounts for over 70% of the distributions of securities sold in the exempt market and approximately 90% of funds raised through the exempt securities. There are a number of categories of accredited investor, which include both individuals and non-individuals. So this first slide really just highlights the qualifications for individuals and how they can qualify as an accredited investor. And the amendments that we made to the accredited investor exemption did not change these tests. The next slide just outlines some examples of non-individual entities that qualify as accredited investors. And again, I think it's important to note that the amendments did not make a change to this list either. So on May the 5th of this year, there were some amendments that were made to the accredited investor exemption. And the changes were largely focused on addressing some key concerns that we identified in the use of this exemption. Namely that investors may not fully appreciate the risks associated with making an investment in the exempt market. And so as we considered this concern, we obviously looked for ways to more prominently disclose the risks to investors. And second, that individual investors may not actually qualify as an accredited investor in some cases. So let's talk about what actually did change. So as I mentioned earlier, no changes to the income and asset threshold in the definition of accredited investor. One of the changes we did make is the introduction of a new risk acknowledgement form that must be completed by individual purchasers other than permitted clients. We also expanded the companion policy guidance on the steps that sellers can take to verify that a purchaser is actually an accredited investor. Another change that we made that was welcomed by the market was that in Ontario, a person acting on behalf of a fully managed account, where the advisor has a fiduciary relationship with the investor, can purchase securities of investment funds. Previously in Ontario, the managed account category of accredited investor was not able to acquire investment fund securities. And lastly, we introduced a new branch of the definition of accredited investor to address family trusts, where a trust is established by an accredited investor for the benefit of his or her immediate family, provided that a majority of the trustees are accredited investors and then the beneficiaries fall within a certain specified family category. For example, a spouse, a child, a grandparent, or a brother. So we're going to spend some time talking specifically about the risk acknowledgement form. So a new risk acknowledgement form must now be completed where the purchaser is an individual and they qualify as an accredited investor under the financial asset test, the net income test, or the net asset test. So this is J, K, and L of the definition of the accredited investor. And the main purpose of the risk acknowledgement form is to provide in plain language a description of some of the key risks associated with making an investment in the exempt market, and also to provide a short, clear description of the categories of individual accredited investor, and to require the investor to confirm which category they meet. Important to note is that the risk acknowledgement form must be completed at the same time or before the individual signs the subscription agreement. It's important in our view for investors to know the risks of an investment before making their investment decision and signing the subscription agreement. We do note that some commenters noted that the accredited investor definition is often included in subscription agreements, and so it should be unnecessary to repeat it in the form. However, in our view, the form is intended to be an investor-friendly document that pulls out the key information the investor needs to know, rather than having included in a long legal document, possibly embedded either throughout the document or right at the back. Another key element of the amendments to the accredited investor exemption is the expanded companion policy guidance on the steps the seller could take to confirm that the purchaser is an accredited investor. This addresses one of the concerns noted during our review, that in some cases the purchasers don't qualify as accredited investors. The guidance expands the existing guidance that's found in section 1.9 of the companion policy, National Instrument 45106, and emphasizes that the person relying on the exemption is responsible for determining that the conditions of the exemption are met. And if there is a registrant that is acting on behalf of a seller, not only must they ensure that the conditions of the exemption are met, but the registrant must also comply with all of its registrant obligations under National Instrument 31103. It's important to note that guidance really goes beyond just the accredited investor exemption and focuses on the need to verify a purchaser's status more generally for those prospectus exemptions that are based on the purchaser having certain characteristics. For example, under the Family, Friends, and Business Associates exemption, there must be a relationship that exists between the purchaser and the principal of the issuer in order to qualify for that exemption. So there are steps that sellers can take to verify that that relationship does in fact exist. The guidance notes that the seller must obtain information from the purchaser to determine whether the purchaser meets the applicable test. In particular, it's not enough to just accept standard representations, for example in a subscription agreement, or to accept that the purchaser has initialed beside a category of accredited investor in the risk acknowledgement form, unless the seller has taken reasonable steps to verify that the representations made by the purchaser are true. In terms of the guidance, what does it mean to take reasonable steps? So first, the seller should understand the terms and conditions of the exemption being relied on, which means that the seller is able to explain the meaning of the terms and the conditions to the purchaser, including if there's any differences between criteria. So for example, under the offering memorandum exemption, the difference between an eligible investor and a non-eligible investor. With respect to the crowdfunding prospectus exemption, the difference between an accredited and a non-accredited investor as it relates to the investment limits. Second, the seller should also confirm that all parties acting on their behalf understand the conditions of the exemption. The guidance states that the seller should have policies and procedures in place to confirm that these parties understand the exemption being relied on and are able to describe them to the purchaser. So for example, if the seller is retaining a registrant to be involved in the distribution, making sure that the registrant understands the terms and the conditions of the exemption. Third, the seller should verify that the purchaser meets the criteria by obtaining information from the purchaser to confirm this. So as we mentioned earlier, it is not sufficient for a seller to rely on standard representations that simply state, I am an accredited investor or a friend of the CEO. The seller should take additional steps to confirm the purchaser understood the meaning of any representations. For example, in the case of the accredited investor exemption, the seller could ask questions of the purchaser about their net income and assets. Finally, the seller should consider what, if any, documentation it needs to collect from the purchaser to evidence the steps the seller followed. So I think what's important to note here is that if the seller or the registrant is meeting with the purchasers, they should be keeping meeting notes, any type of correspondence by way of email exchanges to evidence the reasonable steps that were taken in order to verify that the conditions of the exemption were met. So now I'm going to hand it back to Melanie, who's going to discuss the amendments to the minimum amount investment exemption.
Great, thanks again, Denise. So I'll just start by noting that this exemption is used somewhat less than the accredited investor exemption that Denise just described, but it is still a very significant source of capital raising in the province of Ontario. I won't get into too much in terms of the details of the exemption, as it's pretty straightforward. Basically, it allows any purchaser to sell to any non-individual investor, provided that the acquisition cost is at least $150,000 and is paid in cash at the time of the distribution. Limiting the exemption to sales to non-individual purchasers is quite recent. This was part of the May 5th, 2015 package of amendments to National Instrument 45106 that also included the introduction of the family, friends, and business associates exemption and the amendments to the accredited investor exemption. Unlike the review of the accredited investor exemption, the CSA's review of the minimum amount investment exemption was prompted by the financial crisis. And I will note that the feedback we received, both through our consultation sessions and in the comment letters that we received on our proposal to not allow issuers to distribute securities to individuals under the exemption, was generally quite supportive of this change. And I think this was really in response to a number of concerns with the exemption that were identified during the course of our review. So in particular, concerns were raised about the underlying policy rationale for the exemption itself, this being the idea that by having $150,000 in cash to invest in a single security means that a purchaser no longer needs the protections afforded by a prospectus. During our consultations, we heard from many market participants that suggested that this level of investment does not necessarily assure investor sophistication, nor does it necessarily mean that the investor can withstand the loss of the investment. Requiring an investor to invest such a large amount when they might otherwise choose to invest less was also a concern that was expressed to us. And finally, it was noted that this type of investment could result in an investor becoming over-concentrated in one investment. So with that, I'll now turn it over to Gloria again, who will walk you through the new existing security holder exemption.
Thank you, Melanie. Now this slide presents the key features of the exemption, which can be found in section 2.9 of OSC Rule 45-501. Key points to note is that the exemption is only available to reporting issuers, and only existing security holders of the issuer may purchase securities under this exemption. The existing security holder exemption is a new exemption in Ontario that became effective on February 11th of this year. It is substantially harmonized with similar exemptions adopted by other CSA jurisdictions. This exemption allows issuers that are publicly listed to raise capital from existing investors in reliance on the issuer's public disclosure record. To rely on the exemption, an issuer must offer a class of listed equity securities or units comprised of a listed security and a warrant to acquire the same to all existing security holders holding the type of security being offered. The exemption is not available to investment funds or to issuers that are not in compliance with their continuous disclosure requirements. Given the focus of the exemption on an issuer's existing continuous disclosure record, there is minimal disclosure required of an issuer using the exemption. There is no requirement to file or deliver any offering document. However, issuers must issue a news release that describes the proposed distribution in reasonable detail, including the minimum and maximum number of securities to be distributed, how oversubscriptions to the offering will be allocated, and how proceeds will be used. This must be filed on SEDAR. Under the exemption, an issuer could only increase its outstanding securities of the same class by up to 100%. However, investors will be limited to purchasing a maximum of $15,000 in a 12-month period if suitability advice has not been obtained from a registered investment dealer. If an investor has received suitability advice, there is no limit on the amount that the investor can invest. Now, an offer must be made to all security holders under the exemption, but there is no requirement to allocate the securities on a pro rata basis. However, we would expect issuers to treat all security holders fairly. In addition, the duration of the offer is not prescribed. But if there was a short offer period, we might have concerns about whether the issuer made a bona fide offer to security holders, depending on the facts and circumstances. For example, if an offer period was very short and a small number of security holders took up all of the securities, we might have concerns whether an offer was really made to all security holders. Also, there is no requirement to accept all subscriptions, but rejections of valid subscriptions could call into question whether the offering was made available to all security holders. Two other points to note. First, secondary market civil liability applies to the securities that are distributed under the existing security holder exemption. And second, similar to most other prospectus exemptions that we've discussed today, securities acquired under this exemption are subject to resale restrictions. For this exemption, the securities are subject to a 4-month hold period. Now I'll turn it over to Denise.
Thanks, Gloria. So we're going to shift gears a little bit and talk about the reports of exempt distribution. So as many of you know, in the exempt market, issuers must file a report of exempt distribution under certain exemptions, and this is pursuant to Part 6 of National Instrument 45-106. And the forms to be used, in Ontario, the form that's used is the Form 45-106F1, and it's also used in many other CSA jurisdictions, with the exception of British Columbia that uses Form 45-106F6. In terms of the timing, the form is to be filed within 10 days after the date of the distribution. However, with respect to investment funds, they can file annually for distributions under certain exemptions, for example, the Accredited Investor Exemption or the Minimum Amount Exemption, and that report must be filed no later than 30 days after the financial year end of the investment fund. Examples of some of the exemptions that trigger the reporting requirement are the exemptions that we talked about today, the Accredited Investor Exemption, the Offering Memorandum Exemption, the Family, Friends, and Business Associate Exemption, and the Existing Security Holder Exemption. The report that's filed includes information about the distribution, including the exemption that's being relied on, the amount that's being raised, and it includes a schedule which includes the names and addresses of each individual purchaser. These forms are one way as regulators that we can track the activity in the exempt market. To better facilitate our ability to use the information in these forms, we introduced an electronic version of the form as well. Also, in May of this year, we published OSC Staff Notice 45709, Tips for Filing Reports of Exempt Distribution, and I would note that this staff notice replaces the prior notice that was issued in June of 2012. So on March 20th, 2014, we published 2 proposed reports of exempt distribution for use in Ontario and certain other jurisdictions, and this was Form 10 and Form 11. As part of this initiative, the CSA, including Ontario, published for comment a proposed harmonized report of exempt distribution on August 13th, 2015. The comment period ended on October 13th, 2015, and we received approximately 18 comment letters. The proposed new report is designed to reduce the compliance burden for issuers and help us to obtain better data on the exempt market activity in order to help us more effectively oversee the exempt market. We currently are reviewing the comments and working with the CSA to develop final amendments with respect to the report of exempt distribution. In the meantime, we continue to require issuers to file Form 45106F1 as is currently required, and in BC, issuers are generally required to file the Form 45106F6. So I'd now like to turn our attention to talking about the compliance and oversight programs. Given that a broad group of retail investors will be able to access the exempt market through the new prospectus exemptions, the OSC is developing a compliance and oversight program to monitor distributions under the new capital raising prospectus exemptions. The program will have three main elements: assessing compliance, enhancing awareness, and gathering data. So what do we mean by assessing compliance? So the list that's provided on the slide is by no means an exhaustive list, but it does highlight some of the key areas that we intend to be looking at. As registrants, when we come in to look and we're conducting a compliance review, we'll be checking compliance with investment limits. So what steps did you take to verify the investor was investing within the appropriate investment limit? For example, under the offering memorandum exemption, making inquiries with the investor to confirm first whether they are in fact an eligible or non-eligible investor, and second, whether or not they are investing within the investment limit for that appropriate category over the past 12 months prior to the particular investment you are talking and recommending. Second, the risk acknowledgement form. We'll be checking that you have signed risk acknowledgement forms completed for all investors under the offering memorandum exemption, and that if it is an individual investor, that the new schedules are completed for those investors. The risk acknowledgement form for the family, friends, and business associates exemption. So in Ontario, the requirement that this form be signed by both parties will be something we'll be looking at, as well as the evidence that documents the nature of the relationship as described in the risk acknowledgement form. Third, the due diligence. So registrants must conduct their own product due diligence and be able to explain to their clients the securities and risks, key features, and any ongoing costs and fees. This is not something that's new. This is something that registrants have been doing. And in fact, we issued CSA staff notice 31336 in January of 2014 that provided additional guidance around these areas. But as part of your product due diligence, registrants should review and assess the information contained in the offering document, whether it's under the offering memorandum exemption or the crowdfunding offering. But it's not enough to just review the offering document. You must also review other documentation. For example, if there is marketing materials, and in those marketing materials, if benchmarks are being used and ensuring that the benchmarks are appropriately supported, ensuring that information is fair and balanced and not misleading. You should be looking at the management of the issuer, looking at the constating documents, at financial information of the issuer and or projections if they have them. That's all part of the due diligence as a registrant. Staff training is another area, so provide training for your representatives about the new prospectus exemptions and your expectations for compliance with this requirements. You should consider updating your policies and procedures to incorporate any specific internal controls you establish for compliance with these exemptions. In terms of the offering documents or disclosure to investors, we're also going to assess compliance with your ongoing disclosure requirements. So for example, ensuring that investors are provided the audited financial statements where available to investors, ensuring that the annual use of proceeds is provided to investors. And you as a registrant should be looking at this information and checking that the disclosure to the investors is in plain language and easy for clients to understand the business of the issuer. Another element of the program is enhancing awareness, and this has to do with education and other outreach activities that we hope to be able to conduct for issuers and registrants and investors. Today's webinar is a good example of some of the education and outreach activities that we'll be conducting. And the third element is the gathering of data, and this will help support both our compliance and our outreach activities. We're able to gather data and track information through the reports of exempt distribution and our risk assessment questionnaire that registrants complete, and this helps us to understand how the new capital raising exemptions are being used and how the exempt market is developing generally. So this concludes our presentation for today. We hope that it has been informative. If you have any questions, please feel free to contact the OSC. Thanks so much.